Right, I've been asked to say a few words about the International Court of Justice, of which I was a member from 1991 to 2. And this was indeed a very great privilege for me to be on that court. It is the highest international court and in a sense the highest, and it is given jurisdiction to decide disputes between nations as well as to make pronouncements on matters of international law that are referred to it by organizations or bodies that are entitled to ask for an opinion. As for example, when the General Assembly asked for an opinion on the legality of nuclear weapons. It also has jurisdiction to decide disputes about the interpretation of treaties. There are multilateral treaties signed by a number of countries in relation to various matters of international importance. And if there is a dispute about the interpretation of that treaty, or a dispute between two countries concerning that treaty, that also has to be referred to the International Court. So we have a fairly wide jurisdiction, and it is very interesting to see the range of cases that come before the court at that time about the bloodshed of the 19th century and the commencement of a new century, the 20th century, which should be a century of peace. So in consequence of this, there was a very great peace conference in 1999, I beg your pardon, in 1899, held in The Hague, which was the biggest gathering of philosophers and rulers' representatives that had ever occurred in the history of the world. There is a book, in fact, written about it by the former librarian of the International Court of Justice. It's called The Hague Peace Conference in 1899. And at that conference, they were planning ways and means of making this new century a brand new century of peace. The Tsar of Russia was the person who called the conference, and he had been influenced by the work of philosophers, including, I believe, Buddhist philosophers, and he also was interested in the works of Tolstoy and so on. And he was trying to see whether the disputes that led to wars in the past could in some way be settled before lives were lost. So anyway, this was the Great Peace Conference of 1899. And one of the proposals they discussed was a proposal to have a world court that could decide disputes between nations. So there was a lot of discussion of this, but they could not get it off the ground because the major powers were always reluctant to permit an external tribunal to determine matters concerning themselves, and in that way to be a sort of limitation on their sovereignty. So the proposal to have an International Court of Justice didn't get off the ground, but they were able to have at least a permanent court of arbitration, which started at The Hague at the beginning of the 20th century. Now the 19th century was a century of war. The 20th century was a possible century of peace. Great chance the world had was really messed up, and the 20th century became an even bloodier century than the 19th century. Principally, I think, because the great powers did not want to surrender any part of their sovereignty and give some jurisdiction to an international court. So we had to have another world war, another major war, and there was the Great War of 1914 to 1919, after which they came to the conference table again at Versailles, and this time they decided that they should have a court of international justice. The great powers were prepared to yield one step, but not to yield their absolute sovereignty to this court. And the basis on which the court was created was that the court would have jurisdiction to determine disputes that were voluntarily referred to it by parties, or also by parties who had signed an agreement in advance that they would abide by the jurisdiction of the court. So here was a step forward, and it had its seat at The Hague. It was the Permanent Court of International Justice. And like the Permanent Court of Arbitration before it, it settled a number of disputes that might otherwise have led to hostility and very dire consequences between two countries. So a great deal of good work was done by both organizations. Now, after World War II, which also resulted in a sense from not giving full jurisdiction to the Permanent Court of International Justice, the nations came to the conference table again at San Francisco, and there they created the Permanent Court of the International Court of Justice. The International Court of Justice was in a sense a step further from the Permanent Court, and it was a court where its jurisdiction was linked to the powers of the United Nations. So the International Court of Justice became a principal organ of the United Nations, whereas the Permanent Court of International Justice was not an organ of the League of Nations. So this gave it greater prestige. And of course, theoretically, a decision of the International Court of Justice could even be enforced by the Security Council if an application was made to it for that purpose. So the International Court of Justice came into existence after World War II, and this is the history of the International Court of Justice. It was written on the 50th anniversary of the court. I was then a member of the court, and I had some hand in the production of this book. And it traces the ways in which the International Court fulfilled its role of settling disputes between parties, averting wars, and generally creating a more peaceful world. But still the weakness of the International Court is that it does not have jurisdiction over countries which do not consent to its jurisdiction. So that is the limitation, and that imposes a considerable or creates a considerable diminution of its powers, although it is a world court. Nevertheless, it has done some wonderful work, and I was privileged to be with it for nearly 10 years. Now, when I was there, there were a number of very important cases that came before it. One was the nuclear weapons case, which I've already referred to, which I think was the most important case ever brought before any judicial tribunal at any time, because we were asked to pronounce upon the legality or otherwise of the use or threat of use of nuclear weapons. The court considered the matter for several months. We had a deluge of petitions with millions of signatures from all over the world. There was not room enough in the court's storerooms to house these documents, and they had to be lodged somewhere else. But still, it was a case which attracted worldwide attention. And the court was at that time, it consisted of 14 members, because one member, the Latin American member, who might probably have voted against nuclear weapons, died shortly before the case came to the court. So there were 14 judges, and when there are 14 judges in the International Court, the case is finally determined if there is an equal division by the casting vote of the President. Now, in the case of nuclear weapons, all 14 judges said unanimously that nuclear weapons violated all the basic and fundamental rules of humanitarian law. But there was a slight disagreement on one small matter. It does not turn out to be a small matter really. It gave one window of opportunity for the use of nuclear weapons, named in a situation where a country is under attack and its very survival is at stake. Can that country use nuclear weapons in its defense? We were equally divided on this matter, and the case was settled by the casting vote of the President, who decided in favor of keeping open this window of opportunity. I think that was unfortunate that it went that way, because otherwise we would have had an epoch-making decision of the highest court in the world, telling the whole world that the use or threat of use of nuclear weapons was illegal. Now, I wrote a very strong dissenting opinion saying that nuclear weapons were illegal in all circumstances whatsoever, and there could be no excuse at all for the use of nuclear weapons in any circumstances. And that is the minority opinion that is most often cited today, and that has been used in many cases as a basic and fundamental exposition of the illegality of nuclear weapons. Now, in that case, I did what I had done in many other cases in the court, which is to draw upon the wisdom of all world cultures to determine the international law on the matter. Until I went to the court was administering more or less a Euro-centered monocultural body of rules, which was considered to be international law. But when I was there, I was able to inject into it a number of perspectives from other civilizations and cultures. And even in the nuclear weapons case, I cited the wisdom of Hindu law, where in the great war between Rama and Ravana, Rama was told by his generals that there was a hyper-destructive weapon that he could use, which would ravage the countryside of the enemy and destroy a good part of its population and decimate its armed forces. But Rama was told they may have had something of some weapon very closely resembling a nuclear weapon in those days. There's much of ancient Indian history that is lost today. But anyway, Rama was told that he should not use that weapon without first consulting the sages of the law. They were, I think, in this respect more civilized then than they are now. And this head of state consulted his legal experts as to whether he could use this weapon. And the legal experts said no. And why? Because a nuclear weapon goes beyond the purposes of war. The purpose of war is to subjugate your enemy and live in peace with him, not to ravage his countryside and decimate his population. So Rama obeyed the sages of the law and did not use it. And that is the principle of Hindu law that I brought into my discussion in this case. Likewise, I brought in traditions from all parts of the world. Now, that was one case. Another case, to illustrate the work of the court, was a case between Hungary and Slovakia relating to the damming of the waters of the Danube. There was a dispute in which there was some concern about the way in which the natural vegetation and the environment were disturbed by the damming of the waters of the Danube. And on that occasion, I remember, the whole court went to inspect the scene. And I saw all my colleagues looking at this huge reservoir that had been created of the waters of the Danube. And they were looking at it, admiring its size and the way in which it was constructed. And so much so that I could not restrain myself from going up to each one of them and telling them, you know, this is very small compared to what was done in my country 2,000 years ago. They could scarcely believe me, but because I was saying it, they accepted it. And when I went back to chambers, I gave them all the statistics. And they all came to me and said how pleased they were that I was able to bring this new perspective into their thinking, that there were these ancient civilizations which excelled even in technology, the civilizations of today. And so in that case, the question was about the damage caused to the natural environment. And there again I drew upon ancient religious tradition. And there is this question of trusteeship of earth resources, which modern lawyers think they have discovered that it's a modern legal invention. So I pointed out to them, and I said so in my judgment, that there's nothing new about this, that when the Arat Mahinda confronted Devanampiya Tissa in Sri Lanka more than 2,000 years ago,